A very warm welcome to this MPA podcast. We will be discussing the Procurement Act 2023, which is overhauling the UK procurement regime. My name is Nicky Wright, and I'm going to be hosting today's session. I'm a partner at Gardiner Theobald within the infrastructure business, supporting major infrastructure clients across the UK. Many of those clients, their consultants, designers, contractors, and wider supply base will need to understand the impact, application, and nuances of the Procurement Act 2023. Now, with that in mind, I'm very pleased to be joined today by Kate Gough and Rob Colvin. Kate is a partner in Freshfields' global projects dispute practice. She leads the Freshfields public procurement practice and has a wealth of experience on public procurement, particularly in relation to bid challenges. Rob is a senior associate in Kate's team and similarly has extensive experience advising on public projects and contentious procurement matters. Since the Act came into force earlier this year, Kate and Rob and their team have launched a series of briefings on the new Act and its potential impacts, and are here today to chat through some of its key themes. Thank you so much for joining.
Thank you, Nicky. It's great to be here.
Good to be here. Thanks, Nicky.
So for those of you listening, to get a feel for what we're going to be covering in today's session, I have some questions for Kate and Rob, which will take us through a journey from the fundamentals of the Act and its needs, the inclusion of contractual performance, further information on supplier exclusions, direct awards, and how this has changed the bidding landscape, and importantly, what the future holds. So just a few things to cover in this podcast, so let's get into it. So the Procurement Act 2023, why now, and why did the UK need a new public procurement regime?
It's very good question. So, as you've said, the Act came into force earlier this year, on the 24th of February. And I think in reality, there were two fundamental reasons behind the feeling of a need for reform. The first was Brexit. And then the second was a feeling that even kind of without that, improvements could be made. And there was a kind of a need for consideration of what had become a very detailed and complex set of rules. First of all, the regime that we had before February implemented the EU procurement directives. So it was effectively copying out EU legislation. And I'm sure you and those listening will remember one of the great promises of Brexit was to take back control of our laws, borders and money, and that the government then decided as a result of that bringing kind of procurement law back in-house was a kind of key legislative aim. And the other part of it then was, as I said, a feeling that even without that we could do better. In 23 to 24, approximately 341 billion was spent on procurement in the UK, accounting for about a third of public sector spending. And I feel that recognising the importance of that purchasing power was a need to do that better. The old regime was considered to be complex, inflexible, not fit for purpose, and really not kind of providing a mechanism and a set of rules that was really allowing for the government to use that purchasing power effectively for the benefit of the country and for taxpayers. And so those, I think, are the two real reasons underlying the change and why now.
And I guess one of the key changes in the Act is that we have a legislative framework that no longer just governs the award of contracts. I understand the new Act also covers contractual performance as well.
That's right. And really the mechanisms in the Act as to contract performance and the monitoring of it reflect a real shift in the way that projects could be managed and performed going forward. So it's worth just flagging some of the key points around this. The most obvious one is that there's a general rule now that as a contracting authority, at the outset of a contract, you need to set KPIs, at least 3 KPIs, before entering into a contract of a value of more than £5 million. And there are also prospective provisions which require authorities to assess and report on supplier performance against these KPIs throughout the term of the contract. And you can see what this is all about. This is all about value for money, some of the themes that Kate was talking about, and real accountability for suppliers when they're awarded larger public contracts to make sure that they're doing a good job. And the mechanism to really achieve that kind of accountability is what's called under the new Act a contract performance notice. So this is a public notice, and the intention behind it is to just increase that transparency as to how suppliers are performing throughout the term of a contract. How authorities will set KPIs is yet to be seen, but you can see that just from an instinctive level that there's an increase in potential reputation damage. If you're a supplier and you're not performing, then the market will be able to see that that's the case when your contract performance notice is published. So we're going to see more scrutiny from competitors, but this mechanism, it's all about transparency to the market. It's also conceivable that there are provisions related to the assessment of contract performance that could form the basis of a challenge to a contract. So, for example, an authority that fails to assess KPIs or fails to publish information on performance against KPIs, these kinds of things could conceivably be actionable breaches of duty under the Act. That could, in theory, give rise to a claim that could be brought to set aside a contract or a claim for damages. And you could see how it might be in the interests of a third party, perhaps a disgruntled third party that originally bid for a contract, that lost out on getting the original contract, and that might want to make some hay over the fact that its competitor is performing badly. Opportunity there comes with that transparency for potential disgruntled bidders. I think, it's unclear how this is going to really play out in practice. And one of the hurdles that we've discussed internally is, how as a third party, are you really going to prove that you have a loss as a result of a failure on the part of a contracting authority to publish information about the performance of a contract? Conceptually, that feels like quite a difficult thing to do. So it's really one of these things where we'll need to watch this space, but there's a great deal of interest in the area.
I guess leading on from that, what about the new exclusion grounds and debarment grounds? What's changed in that regard, and what are the kind of main risks, Kate?
It's really interesting. This is definitely the area where we have been getting the most inquiries from our clients. I think, a lot of our clients are pretty familiar with how to bid well, and kind of navigating the old regime, although it wasn't perfect, was kind of something that they'd got used to. And I think that this, it is true that this is a new exclusion and debarment regime. And so kind of really making sure that they understand the changes and also the implications of the changes is like absolutely been top of the agenda for a lot of our clients. So I just find that in and of itself, I think it's quite interesting that that's where people are kind of really looking. In terms of like what's changed, I think there's a lot of change in the language and a lot of change like structurally about how all of this has been put into the Act, but actually there are really two key changes. I mean, the first is there has actually been a kind of recutting and definitely an expansion, I would say, of the actual grounds on which you can be excluded from public contracting in the UK. But then there's also, and perhaps more importantly, there's something called a debarment list. There's a new debarment list, and that just simply didn't exist in the old regime. So I suppose first, if you look at the grounds, what's different? I think, under the old regime, individual contracting authorities could exclude a supplier, if certain exclusion grounds applied, and they were kind of listed out in the legislation, and they were divided between mandatory and discretionary exclusion grounds. So certain grounds, if they applied to that supplier, the contracting authority had to exclude them. And then the discretionary ones where if they applied, they had a discretion as to whether to exclude them. And that kind of structure and approach has been maintained, as I say, using some different language. But what is different is those individual grounds are different. So the list of mandatory grounds is different and the list of discretionary grounds is different. So you need to look, if you're, a lawyer working in a bidding company, you need to look at those grounds afresh and say, actually, we've always been able to say no to these. Can we still do that? Or are the changes in the scope or even just the language and wording these grounds such that we could be caught? And so that is important and is different. The other thing is there are changes to how you look at kind of affiliate entities and through the structure and the application of those grounds and also through the supply chain. And that's really, really knotty how that's been done in the Act. And I think in some circumstances actually really quite unclear. So again, that's causing our clients and us to look at these are grounds afresh and kind of go, well, fine, this is kind of a reasonably familiar ground. It might be, say, about tax compliance, but actually, are we still able to say that it doesn't apply to us if we take into account how this now applies to our affiliated entities or to our supply chain? So I think that's been a big change, is that you do just need to look at it again. And there are some that have caused quite a lot of scrutiny. For example, there are some quite different grounds around exclusion for kind of competition law, non-compliance and those types of things. So I think that has been really quite challenging in a way that I don't think was clear when the legislation was going through the legislative process. And then the debarment list. Now that is just a big change. So people who bid into the World Bank or bid into other kind of international aid organisations or other organisations will be familiar conceptually with the idea of a debarment list. But basically what it is like a blacklist. So if you're excluded, you can be put on this list and it's published, and then everybody knows that you've been excluded from public tendering. And that is huge. That is a whole level of transparency that just didn't exist before. And there are very complicated processes about how you get on the list, how you get off the list, and all of that, which I absolutely will not go through in detail. But what's important is that now, either if a discretionary exclusion ground applies or a mandatory exclusion ground applies, and a contracting authority in an individual procurement process decides to exclude you, they will then have to make various notifications in certain circumstances, and that could then lead to you being added to this debarment list. And once you're on that list, everyone else will be able to look it up and say you will be either automatically excluded from public contracting or automatically excludable from public contracting. And that's a real shift in onus, because before, individual contracting authorities had to make individual decisions made on information available to them, whereas now this is a big kind of almost centralized list. The other thing that I think is really interesting about that is that we kind of wondered how it would be used and when it would be used and if it would be used. And very, very quickly after the implementation of the Act, there was an announcement by the Cabinet Office that they had going to launch a debarment investigation into suppliers after the Grenfell inquiry. Now that has actually been paused for other reasons, but it does show that it has got teeth. And that the Cabinet Office is either going to use its separate powers to investigate and debar, or that contracting authorities will be making these notifications and this list will be used. So I think it is quite a big change. And I think that the combination of the expanded grounds and this list will mean that there will be quite a shift in attitude to exclusion and debarment.
So I guess the first thing that comes to lots of people's minds who might be listening to this is what can be done if you as a bidder or an organisation finds themselves on that kind of list, given what you've said about the likelihood of that kind of being maintained as something quite severe.
Yeah, absolutely. I mean, first of all, don't get on the list. That's my main advice. So, there really is a process in the Act about how you can challenge being put on the list. And that is really quite important for people to be aware of. So what you want to make sure is that you've got visibility of what's happening and that you're looking through the process and you're taking the appropriate steps under the Act to challenge inclusion if that's available to you. But don't worry, if you're on the list, that's not the end of it. You can then ask to be removed from the list. And there was a regime under the previous legislation of self-cleaning, whereby you could show that if an exclusion ground applied, you had taken kind of remedial steps and kind of made sure that you were kind of made good, and you therefore should be allowed to participate either in that particular public procurement or kind of participate more generally going forward. And in the new Act, there are comparable, though slightly different ways in which you can either demonstrate simply that the exclusion ground doesn't apply because you've taken those steps, or that you have taken the relevant steps after you've been debarred or excluded and then debarred, and then you should be reviewed. So reviewed and removed if that's deemed appropriate. So I think it is really important to understand that this is a kind of iterative process. And one of the things that I really like in the guidance that comes along with the legislation that it's not supposed to be punitive. It's supposed to be aimed at ensuring that we're not consistently awarding public contracts to bidders who shouldn't have them, absolutely, but it's not a kind of punitive regime. There's supposed to be a way back if you do actually do what needs to be done. And I think that is important and should hopefully give, although it's not comfortable, it should give bidders peace of mind if they're worrying about all of this. And what it really is it puts the onus on bidders to ensure that they have good compliance programs, to ensure that they have good information, to ensure that they can demonstrate if something has gone wrong, things happen, that's not going to happen again. So, I mean, I think personally that's a real positive step, and we should take comfort from that.
And I guess another big topic, just as important for bidders as well, is the conversation around direct awards. So does the new regime change that process, or does that maintain?
The short answer is there aren't seismic shifts in the regime governing direct awards. It's all broadly still the same. So direct awards can be granted if there's a justification that applies, or in a situation where an authority doesn't receive suitable tenders or request to participate in response to a competitive tendering procedure. So the mechanics are all still there. There are changes that are worth drawing out. So there are broadly speaking, two new buckets of justifications that are in play. And those buckets possibly expand the use of direct awards, or certainly give greater scope for their expansion. So those cover, first of all, user choice services. And then the second bucket is in relation to defense and security contracts. And that's an interesting one that is worth giving a bit of time to. But before I do, there are also two structural changes to the regime. And both of those structural changes are designed really, or have the effect at least of trying to make the whole process more transparent. The first is that ministers will now have the power to pass regulations to designate specific kinds of contracts as being capable of being directly awarded. And this can be used only if a minister considers it necessary to make the designation to protect human life or public order and safety. And this is something you can, if you were sort of on planet Earth over the last sort of 5-6 years, you'll probably guess where this comes from. It's from the pandemic, giving that kind of ability to directly award quickly, effectively, if an event like that happens and you need to do so in the interests of protecting human life or public order or safety.
I think, I just want to kind of hop in there, but, that it's the context of that is obviously a very extreme circumstance, but obviously the way the legislation is drafted, there's an argument as a lawyer anyway that it's quite broad, that power, and there are definitely safeguards built in, and there are requirements to keep any regulations that are brought into effect under review and for them to be revoked when they're not needed. They don't just live forever, but there's actually no detail that I'm aware of, including from discussions with relevant people, about how that duty is actually going to be discharged. And I think although everyone understands the need for flexibility and speed in really difficult circumstances, we've obviously got the context of the COVID inquiry and some of the difficulties around some of the contracts that were awarded in that context. And I don't know, I feel that some scrutiny of these regulations will probably be necessary. And I feel also that there's a risk that all of this will make challenging direct awards very, very difficult, and in fact challenging the regulations themselves, like the stuff that's put in place to deal with those extreme scenarios themselves, very challenging because of the potential breadth of the discretion there. And I just wonder when it's going to be used. And the world is kind of so uncertain at the moment and so difficult that on the one hand, there's absolute need for this, but on the other hand, you can see it kind of potential for not abuse. Obviously, I wouldn't go that far, but just potential for kind of like uncertainty and a bit of kind of a lack of scrutiny around some of that. Just a point that's been on my mind a little bit about all of this.
Yeah, interesting one. I think we have to see how it plays out. Another one we have to watch this space. And just to tack onto that, the second sort of broad structural change I'd mentioned, Nicky, is which I think is actually really significant, and it's similar to the theme that I was mentioning in relation to contract performance, where you have, contract performance notices and that giving rise to heightened scrutiny and potential challenges. The other mechanism that's been brought in the kind of direct award landscapes is this concept of a transparency notice under Section 44 of the Act. And it's a notice that's got to be publicised by the authority, setting out its intention to award a contract directly. And it's really a significant change, I think, from the old regime, in which authorities had quite broad discretion as to whether they publish notices before awarding direct awards. And there will be a few exceptions under this new approach, but generally the transparency notice will have to be published before a contract is awarded. And that's quite significant because it's a big signal to the market. Here's a direct award, it's happening without a competitive process. So people will be able to see it play out before the contract is awarded. And in that situation, you can see that people are going to be thinking hard about whether there could be grounds to challenge the award before a contract is executed. So another one where we will wait to see how it plays out.
So we've touched on processes, regimes, outputs, and the kind of impacts that all parties involved in the Procurement Act have to kind of understand in order to make sure they successfully implement it. And I guess that leads on to talking about what happens when the procurement processes go wrong and then a party does want to bring a challenge. How has the new Act changed that kind of the general bids challenge landscape in that regard?
Yeah, it's a great question, and we've alluded to challenges a few times so far, so it's good to kind of tackle it head on, because bid challenges, they're time intensive, they're procedurally knotty, they're really challenging, fast-paced pieces of litigation where you have to have your ducks in a row, and that means getting your ducks in a row before everything kicks off. And a part of that, we would say, is wrapping your head around the changes that have been brought about by the new regime and by the Act. I think, to our mind, there are three key changes that are worth talking about. The first is standing. Who has standing to bring a claim, to bring a bid challenge? Under the previous regime, you generally only had standing to bring a challenge if you were what was called an economic operator. And that was under Reg 91 of the PCRs. And that would include the bidding entity, so unsuccessful bidders would be able to bring a challenge and have standing to do so, but generally not key subcontractors, and there is case law to that effect. The position under the new Act is different because it no longer contains this concept of economic operator, and that's just replaced wholesale by this concept of supplier. And rightly or wrongly, supplier is not defined right now anywhere in the Act, which really opens up the debate again around whether subcontractors can bring a claim. It means potentially that if that is right, there could be scope for a greater number of potential claimants. The second point to draw out is around standstill period. Now, under the previous regime, the Act contained, as under the previous regime, the Act contained a mechanism of a standstill period. And what we're talking about is the period that starts at the point that a contract is awarded, during which the contract cannot be executed. It's effectively a cooling off period in which potentially unsuccessful bidders can consider their rights and maybe think about bringing a claim to stop the contract from being executed if they think they've got grounds to do so. The new Act maintains that mechanic, but there really are key changes. The first real change is the introduction of what are called assessment summaries. And these are a brand new creation of the Procurement Act. They are given privately to each supplier that submitted an assessed tender, and they've got to contain a whole raft of information, but certainly information about the contracting authority's assessment of the tender, and if it's different, the most advantageous tender that was submitted in respect to the contract. So at the point that you receive your assessment summary, you know the outcome. And in that sense, they fulfill roughly the same function as a notice of a decision to award a contract under the previous regime. But, and there's a big but, whereas under the old regime, the notice of a decision to award a contract began the standstill period, under the new Act, the assessment summary doesn't do that. It doesn't start the standstill period. It is the contract award notice that comes after the assessment summary that does that. So it's a real something to bear in mind, that you'll have notice of what's happened in the process far before the commencement of the standstill period, which will be triggered by the later contract award notice. So those are two of the key points, at least, under the new regime.
The other big point, really, for me, is the automatic suspension. Rob, if you agree.
Yeah.
The new Act codifies what the right to an automatic suspension, and as we've explained in a little bit of detail, but not really so far, is that basically when you have a standstill period after the award of a contract, if you bring proceedings in that standstill period, then the contracting authority loses its right, its ability to enter into the contract. And like under the old regime, so this isn't really a change, that suspension exists until it's challenged in the court, or the parties agree that it doesn't apply. But there is a really key change, which is that to benefit from that automatic suspension, you have to bring the proceedings within 8 working days from the contract award notice, or any longer standstill period that is stated in the contract award notice. Now, under the old regime, it was just that you had to bring the case before the contract was entered into. It wasn't that kind of like short 8-day period. Now, in reality, obviously, everyone used to bring their claims within the standstill period because you were worried that after that they might just go ahead and enter into the contract. But actually, you often had quite a lot longer, subject to the limitation periods, to bring a claim. And what that actually meant in practice, in my experience, is that the parties would have a discussion. So, you say, this thing has gone horribly wrong. We think this has happened. It's acting for bidder. We think you should go away and look at this again, and we suggest that it's in your interest not to enter into the contract, and to agree not to enter into the contract until you've done that, and until we have got the information that we've asked for and we're satisfied that in fact we don't have a case and a claim here, and you should go ahead and proceed. And that often did lead to settlements, or to procurement processes being rerun, not perhaps rerun from the beginning, but small pieces of the process that had been done in a flawed manner perhaps being redone and reassessed. It also gave the opportunity for parties to have a really fulsome discussion, and also quite fulsome disclosure and exchange of information before the party had to take the step of bringing a formal claim, because you could agree between the parties to extend the standstill period, and you could therefore agree between the parties to effectively extend the ability to take a benefit of that automatic suspension, because you could do it. And it's not clear to me that that's still the case under the new Act. It's a really technical point, which I won't go into, about how it's drafted, but the way that the Act is worded, it's very unclear whether the parties can bilaterally agree to extend the standstill in that way and still get the benefit from the automatic suspension. And I do think that potentially is going to not do what it's supposed to do, which make claims less. The idea is to get all of this dealt with without having to go to court. And in fact, I think it might actually mean people have to bring more claims sooner and with less perfect information, which is kind of the opposite what I think, that kind of from speaking to various people in the Cabinet Office as well, kind of in terms of their briefings about what the intention is here. There's also another little funny niggle for me, which is that They're really short timeframes, Nicky, when you're doing these cases. Like, so you've got this 8 days or 10 days as it was, and then you've also got a 30-day limitation period. And it's so unusual in high court litigation to really have only 30 days to decide whether to bring a case. And particularly these cases that are often incredibly complicated. There's really imperfect information. The bidder just has very little information, and really expensive and really risky and not good for the taxpayer. And you've got 30 days. So again, I think historically, you might have had people taking kind of like fairly sanguine approaches about that, and about when time starts to run for those 30 days. And what I am concerned about, and I haven't been able to get an answer from anyone about this yet, is that Rob talked a bit about some of the transparency in the summaries that you get, and Rob talked about getting this assessment summary early doors, and then you get the notices. And I'm concerned that the time, those 30 days, runs in some instances from that assessment summary. So you have even less information and opportunity in some circumstances to bring a case with full information and having had a full discussion. And so I worry that because of some kind of procedural niggles, that bidders are going to have to be pushed to bring more cases more quickly, which is kind of exactly what everyone wanted to avoid. And I also think there's a real risk of people being tripped up by some of these points and not quite getting it right in the first few instances.
I mean, the topic of bid challenges sounds incredibly intricate, but actually highlighting kind of top 3 areas is a really kind of useful way of splitting that. And a word that's been used today is that kind of knotty, there's lots of points to think about and lots of early work that needs to happen.
Yeah, definitely.
So I guess looking forward, we've spoken about kind of what's happened since February, spoken about some of the kind of key points. I guess looking into the future, as we kind of approach the end of kind of the year, what's on the horizon for this?
Well, I think there are a few things bubbling away. Over the summer, we had a consultation that I'll briefly talk about. The government announced a few different possible further reforms to the regime. So the consultation started on the 26th of June in the summer. It ended on the 5th of September. So the opportunity to feedback is now over. The government's now considering everyone's feedback, chewing on it, and we'll wait to see what comes of it. There were a number of proposals in the consultation, and I'll cover just 2 of them. The first is around prompt payment. Now, there's a whole, there are provisions within the Act that we haven't spoken about. I don't think time has really allowed for it, but there are provisions in the Act dealing with prompt payment in public contracts. And broadly speaking, there's a standard of paying invoices within 30 days of receipt, and that term needs to be flowed down throughout your supply chain. There are various policies behind it, PPNs as well. But one of the proposals that's been put is whether contracting authorities should have the ability to exclude suppliers on major contracts who aren't able to demonstrate that they are complying with the prompt payment provisions. You can see why that's pretty important. If you've got major government contracts delivering public services, taxpayers' expense, you're going to want to know that you're engaging a prime contractor that is behaving properly when it comes to paying its supply chain, particularly when there are going to be SMEs and small enterprises sitting behind the whole delivery of the contract. And I guess there's probably a sense, rightly so, of the scar tissue of events like Carillion that happened all those years ago, where you began to see how many construction companies there were out there that were operating on really thin margins. And when those margins get disrupted or they're not paid on time, then the whole structure begins to look very, very frail indeed. So you can see why the rationale is there for that, but a harder approach taken potentially in this consultation that might lead to the exclusion of suppliers that can't show they comply with the policy. The second thing I wanted to draw out again is, and I mentioned this earlier, is on the defence side. So there's a proposal, or there was a proposal in the consultation to empower ministers to designate services and works and goods as critical to national security and therefore exempt under the exemption that exists within paragraph 25 of Schedule 2 of the Act. And again, we've touched on this as a theme before, but it feels like there is a desire to give ministers that added flexibility to be able to award contracts for the purposes of national security, or where national security is an issue, and to be able to get delivery of those contracts rapidly. And it's worth taking a step back here because we are, I think, probably by all accounts in the midst of a once in a generation surge in defence spending across Europe. And although we've been, really eagerly watching to see how the procurement regime is going to be adjusted in this country to work with that surge in defence spending and the attendant kind of pipeline of projects, as yet, there haven't been any hard law changes to the Procurement Act. But what we are seeing, you saw this in the Chancellor's Spring Statement, you see it in the Strategic Defence Review, you see it in the most recent Defence Industrial Strategy, a real desire from government to really reduce the timescales at which defence contracts are being delivered. Really bringing down the levels of inefficiency in the process itself. And that's so it's a really interesting space to be in the middle of and to be watching. But certainly the feeling from government and the strong messages from the defence industrial strategy are that the government and MOD are going to start to make use of what they call the flexibilities within the existing regime. So we're going to start to see, direct awards, being made pursuant to some of the mechanisms that we've been talking about. We're going to be seeing lots of, appropriate levels, hopefully, of contract modifications, in the event of the need for technology refreshes, where there are capability gaps. These are all mechanisms that are being baked in or have been baked in to the Procurement Act that allow for this kind of delivery. And then obviously there's the exemptions piece as well. But that, I think, that particular proposal is part of a much wider wave of people thinking about how do we get the most out of the existing legal structures so that we can deliver what there is a broad consensus around Europe to deliver on the defence side.
I mean, I totally agree, Rob, with what you said there. I think just looking really holistically to the future, there are some who thought perhaps there would be more widespread and wholesale changes in this act. And so I think in reality, first, we're going to have to see, as Rob has said, how contracting authorities will use the changes and the flexibility to really drive effective procurement. And then I suppose whether it all goes far enough. And so actually, is there enough here to really see that change that we all want and that delivery of kind of brilliant public services and public contracts within a really robust framework? So for me, I think that's the future. A few years of just trying to do the best we can, everybody working together, bidders and contracting authority, to deliver for us all. And then, as perhaps, I'm afraid to say, a look again at the legislation and where this might go in the future.
I think that's a really, really good point to end on. And I just wanted to say thank you so much, Kate, Rob, for taking the time to talk through this with me, and for all the MPA podcast listeners for listening. This is a topic that we know is so important for the entire UK, with the significant infrastructure strategy and associated investment that lies ahead, as you mentioned, Rob. So I guess this aligns with your point, Kate, that if you're engaged in bidding for the public contracts, the time to skill up isn't when you face the challenge, it's well in advance of that. So now, and that's how we, drive better use and efficiency as we kind of move into that next kind of few years. So Kate, Rob, I'm aware that we've just skimmed the surface, but we are now out of time. And, your support to the market on where you guys have deep expertise in this, I'm sure there will be some conversations following this podcast. So look, thank you very much. And thank you guys for listening.
Thank you.
Thanks, Nicky.